Hello everybody, this is my legal rant of the day. And today I'd like to talk about the United States Supreme Court, and in particular, its shadow docket. Over the past 3 months, we have seen the United States Supreme Court issue stays of orders of lower courts enjoining the federal government from what the lower courts thought was illegal activity, various types by the Trump administration. The Supreme Court, in almost 90% of the cases, has given the Trump administration what it wants on the shadow docket. Now, what is the shadow docket? Normally, the Supreme Court hears only about 60 or 80 cases a year. But this summer, the Supreme Court has issued orders in at least 18 cases granting relief to the administration from decisions by lower courts that provided preliminary injunctions or temporary restraining orders on the theory that the federal government, the Trump administration, had violated congressional law and in so doing caused irreparable harm. The Supreme Court, however, has sided with the Trump administration without issuing more than very short opinions, sometimes less than 2 lines. Other times, the opinions include dissents by several of the justices. But the conservatives on the court have sided with the Trump administration almost every time, without opinion. And the thing that is most disturbing about this is the Supreme Court doesn't seem to be even following its own standards for when a stay of an injunction pending briefing is appropriate. Normally, there are 4 factors that the court could consider: the likelihood of success on the merits, irreparable harm, the balance of equities, and the public interest. The Supreme Court seems to be considering only one of the factors, the likelihood of success. And its decisions seem to be predicated almost entirely on the likelihood of success, without considering the issue of irreparable harm. But in our jurisprudence, in order to stay an important decision of a lower court, it has traditionally been the case that you must establish irreparable harm. That is, there is no way that money damages could fix the issue, that the government would be harmed irreparably unless there was a stay of the lower court's ruling. It seems that the court is absolutely ignoring the traditional standards of irreparable harm. And unfortunately, I must say, this seems to be political rather than legal. The only explanation for most of these decisions is that the conservatives are trying to protect the Trump administration. This is indeed unfortunate for both the rule of law and for those of us who practice before the Supreme Court, because we are still hopeful that the Supreme Court will apply the law, the traditions of precedent, and honor the basic precepts of when injunctions are appropriate, when stays are appropriate. This court, on the other hand, seems to simply give a knee-jerk reaction to anything the Trump administration wants and finds that they're likely to rule for the Trump administration on the merits of the case. This is not how these matters are supposed to be followed. Without a finding of irreparable harm, these stays are inappropriate. But the Supreme Court, of course, is the final boss in the judicial system. So we are faced with a big problem, which is we have a Supreme Court that's not even honoring its own precedent and its own rule of law. And they're making decisions that are quite harmful to the beneficiaries of federal programs, federal grants, many other matters of importance where the Trump administration seems to be behaving illegally. Many lower courts have found the Trump administration has violated federal law in many respects, and yet the Supreme Court has rubber-stamped those activities, at least pending the outcome of litigation. One would hope that we would have a more balanced approach by the Supreme Court, but we're not seeing it. Instead, we're seeing a Supreme Court that seems to be acting in an entirely political manner. It's quite unfortunate.